Your Honor, my name is Sasha Latypova. I'm an expert witness addressing the court adjudicating C/17/190788 and procedure 23/172. In these cases, the defendants named include Bill Gates, Albert Bourla, the Dutch state, Mark Rutte, and others. This video accompanies my written testimony, and this is a concise roadmap to help you assessing my affidavit. In my expert opinion, the COVID-19 injections as deployed are indistinguishable from weapons. They are deployed under international legal frameworks for military medical countermeasures, all of which bypass normal regulatory norms, practices, and laws and remove all manufacturers' liability. The mechanisms of harm were fully foreseeable and documented in numerous regulatory guidances all over the world. The mechanisms include synthetic RNA and DNA, mediated cellular dysregulation, inflammatory immune effects, and distributed injury to all organs. The mass deployment of known harmful countermeasures using deceptive advertisement as pharmaceutical vaccines and drugs meets elements of democide, depraved indifference, and criminal negligence, leading to mass deaths and injury. Whether it meets the definition of genocide is legal determination for the court. Dual-use mechanisms make weaponization of these injections possible. For example, LNP and mRNA platforms have been recognized as dual-use technologies in biodefense literature. Dual-use means that they can be used both for military and civilian purposes. Synthetic RNA can cause major damage without necessarily coding for any specific proteins. Vaccine platforms also recognized in biodefense literature as a mechanism to deliver this deleterious cargo into human body. And as previously mentioned, absence of meaningful enforceable pharmaceutical regulations or manufacturer liability makes it completely open, makes this platform completely open for weaponization and adulteration by design. These countermeasures were sold in a bait-and-switch scheme to the public as medicine. In the US, Emergency Use Authorization and PrEP Act and equivalent laws in the European Union, including emergency provisions for countermeasures, waived enforcement of pharmaceutical law and created liability shields to manufacturers and administrators of these shots. Mutual recognition agreements allowed European regulators to accept US regulators' decisions bypassing any independent testing. The conditional marketing approval authorization pathway provided veneer of regulation, while, as previously mentioned, no pharmaceutical laws are meaningfully enforced for countermeasures. And this crucial fact was and remains hidden from the public. Military governance and contracting were using to develop, procure, deliver, distribute these shots all over the world. In the US, National Security Council, Department of Defense, and BARDA oversaw the development, manufacturing, and distribution of Operation Warp Speed designed products. Department of Defense funded all contracts for vaccines, whether for American distribution or European distribution, ordering them as prototypes and large-scale manufacturing demonstrations under Defense Production Act. The Department of Defense placed their own staff in all vaccine manufacturing facilities. And global distribution was coordinated through NATO and joint chemical, biological, radiological, and nuclear military frameworks. Contracts for these countermeasures reference civil and military application, which are all hallmarks of defense production. There is substantial evidence of non-compliance with good manufacturing practices, which is the law that governs pharmaceutical purity and honesty in labeling all over the world. For example, in late November 2020, the European Medicines Agency was hacked and data was leaked from it, including emails and Pfizer manufacturing documentation existing at the time, just 2 weeks before global launch of these products. The regulators were clearly bringing up objections to the technical implementation, to the purity of the product. There were substantial problems with manufacture. The integrity of RNA was non-conforming with previous standards. So instead of fixing those problems, the standards were changed. Instead of over 70%, for example, pure RNA to the spec, the regulators allowed the product to contain just over 50% of the RNA to the spec. The Pfizer and other manufacturers used proprietary, unvalidated analytics. Regulators were objecting to it. There were validation methods missing, and the regulators again were objecting to it. Later on in 2022, FDA, when they resumed inspections internationally, issued Form 483 to Rentschler, which is a supplier to Pfizer, documenting severe CGMP violations. And the overall, no regulatory actions were taken, the products were never stopped, and public was never informed about these severe violations to the quality of the product. Even prior to 2020, in 2019, the FDA changed administrative rule allowing to arbitrarily waive inspections for biological facilities. And during 2020, claiming COVID lockdowns and restrictions, they did not inspect any manufacturing facilities prior to launch of these products, which is one of the major requirements for pharmaceutical product to be inspected prior to launch. In conclusion, the legal frameworks designed for chemical, biological, radiological, nuclear attacks and military deployment renders these injections functionally indistinguishable from biochemical weapons. In addition to that, media lies, propaganda, censorship constitute an accompanying psychological weaponry deployed via NATO psychological operations forces. I urge the court to please open the record to full adversarial testing and call opposing experts to testify. I offer to testify under oath and walk the court through all the evidence. Thank you.